Okay, welcome to the Leverett Subcommittee of Judiciary Non-Civil. We'll go ahead and get going. I know Chairman Petrie has to get going for his own committee, so House Bill 1079. Yes, sir, go ahead.
Chairman, today I bring to you, let me get it out here, House Bill 1079. That is, Chairman, there was one iteration of this, so one other, LC 442597. So what you got? Okay, Mr. Chairman, this bill very simply tries to deal with an issue that we're struggling with in certain municipalities across the state. Particularly, we've had a real problem with this on Tybee Island. As you might imagine, on Tybee, we have a small 3-mile island there by about a mile wide, and one way on, one way off. And so, as you'll see here in Chapter 2 of Title 41, this section relates to the abatement of nuisances. And in the current statute, you'll see there on lines 12 through 15, it talks about how public nuisances may be abated by filing a complaint. And what we do here in this bill, on the second page, beginning on line 16, is to really address events that are hosted by a promoter and organizer that is not permitted. So let me give you an example. That just describes what we're trying to do. Let me give you an example of what we're trying to address here. On St. Patrick's Day, to give you an example, we have probably, 500,000 people come to Savannah. And because that is a permitted event and all of the issues are addressed in advance as a permitted event every year. By the way, this will be our 200th, as a side note, 200th St. Patrick's Day parade this year. But it runs smoothly without issues. Law enforcement is prepared, traffic is controlled, sanitation services are provided. Everything is prepared because it is permitted, and we don't have these kinds of problems. Recently, we've had events that literally had 110,000 people on Tybee Island, and on an island as small as I just described, unpermitted events. And so what you have is these events that are created by organizers, and as we say here, promoters, organizers that are organizing these events that are not permitted. And so the city is overwhelmed, and the public is impeded in a multitude of ways. And so what you see here, beginning on line 16, makes it clear that any event hosted by a promoter or organizer that is not properly permitted by the appropriate level governing authority that results in a public nuisance that impedes travel by police, fire service, emergency medical service personnel, or other public safety personnel. That is the issue we're talking about. Recently, between sessions, we had a situation where we could not get any emergency personnel on the island, couldn't get law enforcement on the island. Island was overwhelmed. We had an overwhelming number of drug overdoses. They ran out of Narcan, had to fly more down on the island. It was an absolute disaster. And so what this bill does, very simply, Mr. Chairman, is provide that same complaint process that is mentioned on the front part of this bill, on the first page, is made available to, whether it's a solicitor general or a city attorney or a county attorney, on behalf of the public, can file a complaint and seek to recover on behalf of the public from the promoter or organizer. This bill has nothing to do with the people who are there. It is about those that are, without going through a permitted process, organizing these events. And so the expenses incurred by local governing authorities related to public safety, supplemental law enforcement, traffic control, fire suppression, emergency medical issues, sanitation services, all of that, they could recover with a civil means of addressing this, to recover those costs and expenses from that promoter or organizer. And I will just say one more thing, Mr. Chairman. This reminds me of what we did a couple of years ago with drag racing. The illegal promoters and organizers that did it the same way, that promote these events, we created a path to go civilly after those individuals. That was what we're trying to do here, Mr. Chairman, and I'm glad to answer any questions.
Thank you, Chairman Petrie. Is this, just to be clear, so if somebody wants to avoid, it wants to host some kind of public function or event and wants to avoid being subject to the statute, all they have to do is apply and get a permit?
Absolutely, sir. Yeah, all you have to do is go through the permitted process, which is what everyone else does.
And as I understand it, the general public cannot initiate this kind of proceeding. It'd have to be an official like a DA, Solicitor General, City Attorney, or County Attorney.
Yes, sir.
Okay.
Yes, sir.
I think you have a question from Chairman Silcock.
Thank you, Mr. Chairman. Thank you for bringing the bill. I was just curious if there's ever a situation where somebody, if they did get a permit and more people showed up than or expected, has that been the case, or these are just totally unpermitted events?
Yeah, so these are, what we're speaking about here is an unpermitted event specifically. So it wouldn't really address an event that was properly permitted and then you had a larger crowd. I think that's contemplated by local government. When they have a permitted event, they always know to expect plus or minus.
Okay.
This is a completely unpermitted event.
Okay.
That basically the municipalities are overwhelmed by. I do need to mention in that vein, so GMA is here and they support this measure, and I want to call attention to that as well.
Any other questions, Madam Chairman?
No, thank you. Thank you.
Thank you. Any other questions for the sponsor? All right. Well, thank you, Chairman Petrie. Do we have anybody else here to speak to this bill? I don't see anyone signed up, Mr. Chairman.
Move do pass.
I have a motion to pass. Do I hear a second? Second. Any further discussion? All in favor say aye. Aye. All opposed like sign. All right. In the opinion of the chair, the ayes have it.
Thank you so much.
Thank you. All right, I'm going to go a little out of order. I notice some folks who are going to speak to House Bill 1123 have a conflict. We're going to get to you just in a minute. I want to do first House Bill 827. That is sponsored by my chairman, and so laying all business aside, of course, I want to get to that first.
Thank you, Mr. Chairman. I appreciate that. We've been waiting since the last session for this one. I bring to the committee today House Bill 827. And short and simple, this bill provides enhanced penalties for theft of livestock here in the state of Georgia. And with this penalty increase, this will help hopefully to ensure that producers of livestock and different agricultural products as far as cattle, hogs, chickens, goats, sheep, guineas, you name it, this will help tamp down on that. Was speaking with the Department of Agriculture over the weekend, and there's been some theft going on here in the state. Several years ago, for those of you that were around here, Chairman Perkle had a bill dealing with making sure that those cattle that are taken to sale belong to those that are dropping them off or an agent thereof. So this is a huge issue. I can tell you that it affects small and large farms across this state. I would note, though, for the small family farms that are hanging on, which we see a lot of us are barely hanging on north of I-20 now, you have just one cow-calf pair stolen out of your pasture, and you're hurting big time. Not to mention if you invest in a good stock bull, that cost can be very hard to replace. So you'll see Section 1 elevates maximum penalty for theft of livestock from 1 year to 2 years. It elevates the maximum penalty from 10 years to 15 years. And it elevates the maximum fine from $1,000 to $10,000. Section 1 would also elevate the penalty for theft of livestock bad at less than $100 from a misdemeanor to a misdemeanor of a high and aggravated nature. Additionally, we'll have an amendment that we're working on, just so members of the committee understand this, to help the Department of Ag with their enforcement powers. And what I would say, until I get the actual amendment, I'm not going to try to confuse the issue too much. We'll attempt to do this in full committee, but just so everybody knows what my amendment or substitute will show, if you look at Chairman Perkle's House Bill 1127, Section 1 of that bill, and Section 1 only, is what we would be incorporating here, trying to help our folks over there deal with this very issue. So, Mr. Chairman, that's the bill, and I'll stand for any questions that somebody might have.
All right, Mr. Chairman, thank you. I believe Representative Kendricks had a question.
Thank you, Mr. Chair. I'm a city girl, so you're going to help me with this. So they're stealing livestock stock and then selling a cow on the side of the road, or how are they?
So, usually, generally, there's different ways to sell livestock. And when we say livestock, no, it's more than just cows or pigs. It's chickens. I mean, any animal that we have livestock in this state. You can take them to a sale barn. You could sell them right out of the pasture. You see a lot of folks, they'll try to use the marketplace, Facebook Marketplace, such as that. So that's generally how this would occur. They could take them to the sale barn, although thankfully with Chairman Perkle's bill, we've been able to tamp down on that. Now, you go over the line where we're at out in West Georgia, we've got the Ranburn cattle barn down the road. I know they've got some good compliance measures over in Alabama, but there could be a foreseeable cattle auction somewhere that was not as compliant with ensuring that those who are dropping those livestock off are the actual owners or the agent with the proper authority to be dropping those off for sale.
Any follow-up? Thank you, Representative Kendrick. Any further questions for the chairman? And is anyone here to speak to this bill? Come on, Dale, have a seat when you're ready.
Chair, Vice Chair, members of the subcommittee, I'm Dale Sandlin. I'm the Executive Vice President of Georgia Cattlemen's Association. We applaud the authors. We applaud the authors of the bill, specifically due to the fact that the cost of these cattle has gone up significantly since this bill was first put in 1974. Since 1980, the value of a cow is $695. When it was further amended with $750. Now the value of those cattle are $2,500 on average for a cow-calf pair. The theft does still occur. It's happening more and more so in the direct vein of commerce, where a producer buys those cattle, then buys them on behalf of someone else, and then takes possession of the cattle before paying for them. And so that's typically where it is. As was mentioned, cattle producers tend to be land rich and cash poor. For the fact that you've got 9 months of investment in that animal, in that calf, before it can sell, or up to 18 to 20 months, it gets to be a considerable cost, and this would go a long way to helping provide some peace of mind to the cattle producer.
Thank you. Any questions for this witness? I don't see any.
Thanks, sir.
Thank you, sir. Anyone else wish to speak to the bill? All right, I don't see anybody. Has anyone signed up? Signed down? Just now, okay. All right, well, the chair would entertain a motion. All right, I have a motion do pass in a second. Do I have any discussion? All those in favor signify by saying aye. All those opposed, like sign. All right, thank you. That's on to the committee. All right, now, and before we start, I'll call House Bill 1123 next. Just want to make an announcement. The sponsor, at the sponsor's request, we have pulled House Bill 1118 from the agenda today, so we will not be taking that bill up. So if you're here for House Bill 1118, unfortunately, we won't be discussing that today. All right, let's see. There's Carter here? All right. That's right. He had a hearing for education. So. Okay. All right. Let's hold that one for right now. Let's just go back to, is Representative Bruce here? There he is. All right, Representative Bruce. Thank you for being here today. Why don't you fill us in on your House Bill 882?
Okay. Thank you, Mr. Chairman, members of the committee. Glad to have an opportunity to come. Those of you that have been here for a minute know that several years ago we passed a bill that dealt with mugshots, where you get arrested, you get exonerated, and the sheriff takes the mugshot down, but others, both within the state and outside of the state, have the mugshots up on their sites. And then when you ask them to take it down because you've been exonerated, they say, send me $500 and I'll do it. And you send them the $500, they take it down and they put it up on another site and want you to pay another $500. So the bill that we passed basically made it illegal to charge to take the mugshots down, thought being that if you couldn't charge to take them down, why bother to put them up? But they found a way around it. And what they're doing is they're selling ads and using the money from the ads to keep the site up and those mugshots up on those sites. So this bill is to address that issue, to make it where they cannot do that. And it also provides for civil remedies, in the event that someone does do that. Now there are civil penalties that can be imposed. It also says that basically you're innocent until proven guilty. And as you know, a lot of companies, I was in human resources for 30 years, and so I had to hire a lot of people. And I'll be quite honest with you, there were times when you saw a mugshot and you didn't read any further. And so people were denied employment opportunities. They were denied opportunities to get mortgages, all kinds of things, because these mugshots were out there and the person had been exonerated from whatever they were charged with. So that's what this bill does. The bill is co-sponsored by the chairman of this committee, as well as the chairman of the other Judiciary Committee. So it is bipartisan. Everybody's on board with trying to protect people, their right to be innocent until proven guilty. That's it.
Thank you, Representative Bruce. So to be clear, then, it doesn't. It prohibits someone from posting that photo until there's a conviction.
Correct.
And then it prohibits someone charging
To
some
remove
kind
it.
of fee to remove something that they've posted.
Correct.
And then does it make it a crime to do that?
Yes.
Okay, it does. Misdemeanor, I'm assuming?
Yes.
Okay, all right. I think you've got a question. Is that Representative Neal?
Thank you to the chair. Thank you for the bill. I did have a few questions. I support the bill. Let's start there. But I did have a few questions. So, like on lines 37 through 43. So confirming, I thought you said we already passed the bill that
37.
37 through 43. It looks like new language, but to your point, you said we already passed the bill that did this part, right? Remove it without charge?
Yeah, they're not allowed to, under current law, they're not allowed to do it.
So what is the new language? Can you explain 37 through 43?
Looks like they just repeated what was already in the law.
Right. That's what I was like. It shouldn't be underlined unless there's a change or. And while we're looking that up, I'll shift over as well. So how can you address how this, is it still public on the sheriff's site?
Yes. If they are convicted.
Is it not true? Now, granted, I haven't looked up somebody in a while. Aren't those still public upon arrest right now?
Yeah. That's not addressed in the first bill. All the first bill does is says that you cannot charge to take it down. And the thought process was if you couldn't charge to take it down, why bother to put it up?
But either way, when you still do a search, you can still get on the sheriff's website. Yes.
Talking about now, yes.
My
Okay.
understanding is the bill would not limit the use of photos by law
By
enforcement.
law enforcement.
It's just with respect to someone publishing them in a publicly available publication,
Exactly.
like a Bad and Busted or something like
Right.
that.
So it will still be available on the sheriff's site.
Yeah.
Okay. Gotcha. So can we back up to 37 through 43? Just clarifying what it's doing or what we're doing now if this was already done under the old bill.
3743 is saying that you can make a request. The chairman left out because I think this was one of the pieces that he added to the bill, actually.
Which one is that?
37.
Oh, 37 to 43, okay. I think
Yeah.
what that provision is saying is if someone violates the code section, that gives you sort of a formal procedure for making a demand to take the photograph down.
Okay.
And it makes sure that the person requesting that the photograph come down provides sufficient information to allow the publication to determine what photograph is an issue.
Yes.
Gotcha. Okay, perfect. All right, that's all I got. Thank you, sir.
66 is pretty controlling, because it really just says that it's not gonna apply to anybody unless they're soliciting or accepting a fee for payment to remove booking photographs, or the person or entity's primary business model is the publishing and disseminating of booking photographs for commercial use.
Right, and the actual code section as it currently exists just would apply to, it prohibits arresting agencies from making these photos available in certain circumstances. And I think that was in C. And I believe that's been stricken because we're basically saying you can't release it until there's a conviction anyway.
Conviction.
So, okay.
I believe there's someone here that wants to speak to it.
Okay.
Also.
Yeah, we'll get to that. Just any further questions for the sponsor? All right, I don't see any. Representative Reeves, thank you.
Thank you.
I'm sorry, I was looking at Matt. Representative,
Okay.
excuse me, Bruce.
Thank you, members and chairman. Looking forward to keep moving.
Yes, sir. Yes, sir.
Thank you.
Now, I think Maisie, did you signed up to speak to this, I think? When you're ready.
Thank you. I'm Maisie Lynn Gerton. I'm the Executive Director at the Georgia Association of Criminal Defense Lawyers, and we do come in support of restricting the use of people's booking photographs unless and until they are convicted. I just wanted, based on the conversations happened today, I just wanted to clarify. Another reason we like this bill is it's not exactly criminalizing it, it's allowing for a civil penalty, not a new crime against the perpetrators of the extortion type behavior that it's concerned with curbing. And I've spent a little bit of time looking today to see the impacts on the sheriff's websites, and right now, the current language in 35119 prohibits an arresting law enforcement agency or agent thereof from posting booking photos to or on a website. That's subsection B of 35119, which is, embedded in this bill. And I just did a quick look at a couple metro sites, and it does appear that at least Cobb County is refraining from putting images out now. You can still receive, you still see all the information about the person, that's name, date of birth, race, gender, days in custody. So it doesn't seem to me that this is going to change anything about the status quo of the way the sheriff's departments are operating right now. It is going to, though, protect people from all of the deleterious effects that Representative Bruce mentioned have been flowing from these problematic actors in this space. If we had our druthers and more time, we would ask that you require these companies to register in our state, or at least have a registered agent here, because one of the problems that we find with trying to enforce these problematic publications and ask for cease and desist to occur is locating them, because so many of them are offshore. But that's a fight for another day. We wouldn't want to slow this good work down, but do want to let you know that that's part of the problem here, is that these actors are operating in our state without registering here. Hard to access them.
Thank you. Any questions for this witness?
Thanks.
Thank you. I would note, looking at the statute, there is a section D, subsection D, that's not in the bill because it wasn't amended, and it does make giving a false statement in order to get the photo is a violation of 161020, which I'm assuming is probably some kind of false statement or false swearing or something like that. So there's a criminal penalty, but to your point, this bill does not add one and does not make refusal to take the photo down a crime. It just subjects you to civil penalty. So thank you for clarifying that. Anyone else wish to speak to the bill? All right, I don't hear anybody. Do I hear a motion?
I move to pass.
I have a motion passed. Do I have a second? I have a second. Any discussion? All right, I've got a motion and a second on the table. All those in favor signify by saying aye.
Aye.
All those opposed, like sign. All right. All right, thank you, Representative Bruce.
Thank you. Members of the committee.
All right. Let's see. Excuse me 1 second. I'm going to reach out to Carter here and see where he is. Would y'all like to go ahead and just give your testimony, or are you gonna have to leave shortly, or? We can wait, okay, all right. Let's see, just going back up. Representative Daniel, do you wanna go ahead and present your House Bill 1038? Just when you're ready.
Thank you. So I'm here to present House Bill 1038. And how I talk about this, I do have a friendly amendment to change 4 words. Well, yeah, okay. But the idea of this bill essentially is when people seek IVF treatment, so patients will go in, they cannot have children on their own, they will seek treatment, and they are artificially inseminated. Currently, it is not illegal for a doctor to inseminate a patient with material that they did not consent to. And so this bill aims to fix that and put into place criminal liability and criminal liability. So any questions? I think it would actually be easier than trying to explain it.
All right, you do have a question, Chairman Silcock.
So, Representative Daniel, my question is, if that did happen, and I suppose someone would have a child, I guess the proof would be by genetic test?
Yes, ma'am.
Okay.
All right. So I guess as you summarize the bill, this is basically it turns on the lack of consent to the specific material or donated material being used as part of that process.
Correct.
Right. And you mentioned, well, you've got another question. Let me go to that first, and then we can maybe talk about your amendment.
Yes, sir. Thank you to the chair. Thank you for the bill. So I guess I'm trying to compose my question. So confirm is a sperm donor.
It could be either. So eggs are also donated. So it could be sperm or an egg.
So is there if you like to either by way of just provide some type of example of the crime. What does the crime look like? How do you steal eggs? Steal sperm? Like,
Okay.
what does that look like?
All right, so I will give you the example. So if my husband and I were not fertile and we went to a facility and they wished, and we said that, I would like his sperm to be used and I would like to be inseminated with his sperm, then I found out later on that they used their own or someone else's other than my husband's, who I consented to, then it would be a crime.
What is the malicious intent? How do you determine intent
So
versus an accidental error at the hospital or whatever the establishment is?
yeah, so there are standards in place currently in the industry that protects if it's like an accident or a lab mix-up or anything like that. That is not. So the industry is actually in favor of this. I have them with me today. But in terms of, so it's actual knowledge. That's part of the amendment that's actually going to be made, is adding. So currently it says intentionally. Let's see, online. Is this an appropriate time to talk about the amendment? Sure. Okay, just so that we're all talking about the same. So on line 20, it says a physician commits the offense of reproductive battery if he or she intentionally, so we want to keep intentionally, but on 21, transfers or implants into the body of a recipient human reproductive material from a donor. On 22, we are going to change. We're going to strike knowing the recipient has not consented to the use of the, okay, so just strike that. And in its place, it's going to read, with actual knowledge that he or she is using human reproductive material from a, instead of such, donor. And then after donor, it's going to read, for which the recipient has not provided consent.
Okay.
And that's kind of like a double layer, essentially, to just make sure that it's tight enough that that's not a concern.
Gotcha. Okay. Thank you.
Thank you, Representative Kendrick.
Thank you. Thank you for bringing the bill. I have two questions. So I saw, I'm not saying this is where the bill came from, but I saw the Netflix documentary. And at the end of it, one of the reasons they couldn't charge the person in the film, and this is happened in real life, was there was a gap in, and I forgot what state it is. They couldn't charge him with regular battery. Like the prosecutors were trying to charge him with battery, but they couldn't for any number of reasons. So is my understanding that you're trying to fill in that gap. So if it happens here in the state, there's not going to be that legal issue of, we tried to charge him with battery, but because they sort of consented, right? Because they consented to being inseminated, but they didn't consent to sort of some other things. The prosecution will have the tools that they need to prosecute under this. Is
That is correct.
okay? And then my second question is on line 52 through 54, that the physician who violates this code shall be subject to revocation. I'm just trying to understand the word subject to revocation. So you're saying that they would qualify to have their license revocated, but it wouldn't automatically happen.
Correct. So currently, the way other crimes are handled in the medical industry, it leaves it up to the Georgia Composite Medical Board. And so this would just follow suit with what's already in place for other medical malpractice, I guess, per se.
Yes, ma'am.
So there's no crime in which the legislature puts in the language that it shall be revocated. We always leave it to the.
Not to my knowledge, yeah.
At least in the context of medical licenses, apparently. Yeah. Representative Neal.
Yes. I do have another question that spawned in my brain. Say this happens and the person is impregnated, what have you. And this is not a political question, let me preface with that, but do they have to keep the baby? Like, are they allowed to get an abortion if they've become a victim of this? Are they now forced to keep the child, or do they have the option to have an exception when it comes to abortion?
I do not know. I would say that whatever's currently in place is what would be followed. I'm not sure that they would have the ability to test DNA in utero. I could be wrong on that, but I'm not certain without being an expert in the medical field on whether or not that's possible.
Yeah, it's not a statute we're touching today.
Yeah. Don't do that to me today.
I'm trying to work it through. Okay.
Any follow-up? Representative Neal?
No, sir, I'm good for now. Thank you.
I would also just note, you're making this act a felony, 1 to 5 years, and a fine not to exceed $5,000 unless it's the physician's own material, and then it's an enhanced. It's 1 to 15 and a fine not to exceed $10,000. Plus, there's a provision on a statute of limitations that doesn't begin to run until discovery.
Correct.
And then we've also got a provision for a civil cause of action in here as well that allows recovery of compensatory punitive damages, cost of litigation, and injunctions to stop whoever's doing this from continuing to practice, as well as the potential for having the license revoked.
Correct.
All right. Chairman Silcock.
So I guess I'm along the lines of Representative. I'm curious. I guess I would imagine that we wouldn't discover this until the child was born. I'm assuming that we wouldn't discover it, and then of course a genetic test would have to be done and gone back. And so, I mean, if the statute of limitation is not going to start until it's discovered, I guess it could be till someone was whatever age, right? I mean,
Correct. So one of the things, so this has happened in other states, and one of the things that has taken place is there's a rise of 23andMe and other DNA testing devices where people send in their DNA and comes back. In other states, they have actually found pockets of siblings that did not know they were related. Upwards of 40, 50 siblings, and it has rooted back to this. And so the issue that we're really trying to address here is twofold. One, you don't want this happening to women. But two, the children of the people that, these victims really, of these victims can grow up. The world is small. A lot of times people don't move from where they're from. And there is the potential that they would end up with their sibling unknowingly and then have a child with, some type of abnormality or deformity. And so there's a lot of reasons to do this. That's just one of them. Another example that we've seen in other states was there was a case where they picked a donor. They had no previous medical history of any concern. And when the child reached, I want to say somewhere between, 17 or 20, they developed schizophrenia. And the parents found out that the donor they consented to was not the person that created the child. And in fact, it was someone who had schizophrenia. So you get into this whole realm of, how do you know if this pertains to you? And the only way that you would know is a genetic test. And so we're trying to give recourse if that happens.
okay. Thank you.
Thank you, Shirley. Representative Kendrick.
So on line 49, just trying to understand the language when it comes to recovery of damage. It says any person injured directly or indirectly. So does that mean the aunt of somebody who maybe had been inseminated wrongly, or does it mean the godmother of a child that's born out of insemination? I'm trying to visualize what does any person injured directly or indirectly, because I can see that going very, very broad.
Okay, so the way that I believe it is so directly would be the person it happens to, and indirectly could be the father. So if, or the child theirself. So if the result is that they have an abnormality or some type of issue, then they would be able to receive damages for that as the child in the. So even though they're not the victim, they did have a side effect of the action.
So it's your understanding, if I can get a follow-up, that the indirectly portion would only pertain to the father and the child and nobody else?
That is my understanding.
Any follow-up?
Not
Right now, anyway. Representative Neal.
Yes, sir. Thank you. So I had a question, and maybe this is outside the purview, but would a victim then still just fall into the traditional options as far as child support and all that kind of stuff from the suspect if they're the father, even unknowingly or accidentally?
I'm not sure Representative Daniel can give us a legal opinion on that.
Okay.
I mean, that I think would be a possibility, but the bill doesn't purport to address that issue.
Yeah. Okay.
Shirley Silcox.
Thank you, Mr. Chairman. I guess my question would be, I think there would be a reasonable basis for someone who, for example, a grandmother or someone who was a caretaker for many years of this child and expended lots of funds and energy and time invested in that person. I would think they would also be able to recover damages.
Right.
Representative Neal, did you have another question? I'm not sure if I hit your button after you had initiated or at the end of that last thing. Okay. But one question, Representative, the provisions about injunction in lines 40 through 48, and I'm assuming without it necessarily expressly saying so, that would allow a court in a civil proceeding to issue an injunction against the actor, against the bad actor.
Yes.
Is there any other sort of use or possible scenario in which an injunction could be issued, at least as you conceive the bill?
Not to my knowledge.
Okay. I knew it was going to happen at some point. Representative Neal.
Sorry. Sorry, it's a thing about this committee. So, and please direct me there. Is there recourse for the person, not the victim, but say the man that the sperm was stolen from, or the other party, male or female, that I don't know the proper word. I don't know the scientific words for these things. The sperm or the eggs or what have you, that was those items that were taken from that person. Where do they fall in this? They're not the victim, but they were a victim of something.
Yeah, so I think that's actually, so the example would be the partner that it would be the indirectly. That would be it would fall under indirectly, yeah.
Okay. That's all I got.
All right, thank you. All right, any other questions of the sponsor? All right, thank you, Representative. I think we've got some folks that wanted to speak to the bill. Maisie, it looks like you've signed up.
Do I stay or move? I don't know how this is supposed to
Yeah,
work.
why don't you move to let her get to the microphone, but don't go far.
Okay.
Thank you for hearing from us on this bill as well. I have not had a chance to speak with Representative Daniel herself, but she did send a representative to speak with me when I made a request this morning. And I am not yet certain that the language that's been put forth as a possible amendment fully addresses the concerns that we have about this bill. It's possible, mainly because there's nothing in lines 20 through 23 that focuses in on assisted reproduction. And it would be our suggestion, in fact, I did provide some language late this afternoon, based on what Colorado has passed in this space, to provide for a definition of assisted reproduction as a method of causing pregnancy through means other than sexual intercourse, and then adding that to this subsection B, so that it's clear that that is the purpose of this transfer of human reproductive material. our initial concern when we read the bill as filed was that these are the moments I kind of wish Senator Setzler was still over here, because I think he and I could have fun with some hypos. But truly, as filed, we have some concerns that a physician having consensual sexual intercourse could run afoul of this law, even though we all know it's intended to address assisted reproduction. So our suggestion only is to just make sure it's as narrowly tailored as possible to this particular context, and it has been narrowly tailored in other places, and we can look to that language. Looks like Representative Neal is ready to ask. Ready.
So, have you provided that language to the sponsor?
Yes, sir.
Have you seen the proposed?
I have,
Okay.
just sitting here.
So
The proposed language it addresses the knowledge aspect. It doesn't seem to me to address the purpose of the transfer of the material.
So your concern is the way the bill is drafted, it is not clearly limited to the scenario that we're all envisioning where it would apply.
Absolutely.
Okay.
Yes.
Okay. All right. Representative Neal.
Trying to see if I want to go down this road or not. So 2 questions, I guess. Where are you saying? How are you saying that? In what aspect is this not applying? 1, and 2. If you would indulge me, you made a reference to a physician's consensual sexual intercourse.
Yeah.
Relates to the bill.
Sure. So I'm not saying this doesn't apply to assisted reproduction. It absolutely does. It's
Your
just
concern
not
is
narrowly
broader.
tailored to that. It's
It could be
broader.
broadly
Right.
defined.
Because the definition of donor simply is designated as a person who donates, without a definition of donate, human reproductive material, which is further defined down below as what's essentially sperm and eggs, whether for personal use or compensation. Again, it doesn't limit it to the assisted reproduction context. That's one place where you could limit it, is by just narrowing that definition a bit. But then so knowing that that's the definition of donor, along with the others, if you start at line 20, a physician commits the offense of reproductive battery. In this case, it's only going to be through the transfer of sperm. We don't obviously transfer our eggs in sexual intercourse. So if he intentionally transfers or implants into the body of a recipient human reproductive material, his sperm, from that donor, and like I said, as filed, but I still think even potentially as amended, knowing that there wasn't a consent for that material to be transferred. So consensual sex, wherein the agreement is we will use prophylactic protection to ensure that sperm is not transferred, wherein the person nefariously allows sperm to be transferred. And then later a baby is born, and now we're at having to figure out these dynamics. It may sound outlandish. I realize that's not what's contemplated here, and no one's trying to, but these kinds of
You're just trying to make sure the language is narrowly tailored to address the evil
exactly what we're trying to, yeah.
So I guess is it appropriate to whatever the proper medical term is? Needs to be addressed in lines 20 to 22 to say something along the nature of transfers or implants into the body of a recipient human reproductive material from a donor during a procedure, a proper medical procedure.
Possibly, like with the language that's been put forward, you would do, I think, from a donor for which the
So you
recipient
remove
has
the
not
sexual.
consent for assisted reproduction.
You remove the sexual intercourse scenario by adding
By
the actual.
adding something about assisted reproduction.
Okay.
Yes, ma'am.
Gotcha.
As a possibility.
Thank you, sir.
I've been puzzling since my conversation this morning around the fact that at lines 32 and 33, there's a disallowance for the use of consent to an anonymous donor as a defense when an element of this crime is consent. And I understand the basis for it in the sense that, let's take a scenario where, in the most, I would say, egregious case of a physician who has supplanted donor eggs or sperm with his or her reproductive material, unbeknownst to the recipient, and knowing that the recipient had agreed to an anonymous donor, still arguably an anonymous donor, I understand the basis for not wanting that to be a defense. Like I said, my brain's still pretzeled around the idea that it's not typical for us to have an element of the crime be something that we can't defend against. And I just don't know. I'm not ready to say it's like the end all here. It's not a typical way that we limit defense, I would say, in either the civil or the criminal context. And so, though I understand the rationale for it, I just remain troubled by it being laid out as a.
Well, I had, and I think you point out a potential issue that might need some clarification, but I had viewed D as being a defense to the offense of reproductive battery that is described in C2, where it's the physician's material.
Which I did mention this morning when we spoke, that could be a possibility of limiting, like I would feel better about it if it was limited to C2, though at this point in time it's not, of course. It does feel much more on point for the very physician themselves to not be able to use that defense when it's their own material, because that would be an exceptional level of knowledge for the act. In addition, as was discussed earlier, there is, I just wanted to raise the issue to the extent that the civil issues, and I realize I am a little outside my realm with civil cases, I will defer to those of you who hear, but the idea that was discussed with me this morning too was that no one is trying to criminalize negligence, but there is a need for a remedy when a doctor is negligent in this space, in this way, and that would be a civil action. And the idea being that beginning at line 34, you open the door, beginning at line, really, 37. I guess 37, you open the door to the civil actions that would, in theory, be predicated on negligence. However, the way that the language is crafted, you would be able to seek relief from conduct constituting a violation of this code section, which seems to me to be tantamount to criminal, right? Yeah. That if you wanted it to be available to a lower level of negligence so that, the families could get the true remedy that they need in the potential damages, it's a little high bar to have to establish the crime and the negligence if it's only a negligence situation. And I think that would be true all through that section, line 49 also. And then I'm not gonna, I'll leave the rest of the stuff you've talked about alone, but those are the pieces that have caught our eye and we have worked on talking through today, and hope that we could find some additional compromise beyond what's been changed so far.
And what was your suggestion? Were you proposing or just discussing the possibility of adding a definition to assisted reproduction and then adding that concept or phrase into the definition in B, or
Yeah.
the elements of the crime in B?
Yes, sir.
Okay. All right. Any other questions for this witness? All right. I don't see any. Madam Representative, I was going to let you address some of these changes, but I thought we'd go ahead and hear from the other witnesses first. Dr. Andy Toledo. Go ahead when you're ready, Doctor.
Thank you. Thank you, Mr. Chairman, and members of this committee, subcommittee. Thank you, Representative Silcox is my representative, so good to see you on this subcommittee. I'm here, first of all, as a reproductive endocrinologist and fertility specialist who does these things that not the things we're talking about, but I'm feeling a little icky right now.
Do them the right way.
Yeah, right. Do appropriate things. I've been doing this for about almost 40 years here in Atlanta. And so I represent the physicians that do this kind of work, as well as I'm the legislative chair for the Georgia OBGYN Society, so I represent the OBGYNs. as a general rule, I mean, we support the amendment that Representative Daniels has added to this bill. I think I'd like to do two things. One, for those of you who are having questions about all of these things, I'm here to help because this is confusing. And secondly, just to say that we understand why this bill was created, and I do believe it came out of the Netflix series that basically talked about the doctor, using his own sperm to impregnate about 90, I think it was like 94 women. It was a lot. And, obviously, obviously without their permission. And so I don't think any of us who do this kind of work have a problem or an issue with when a doctor, he or she intentionally misuses material or sperm and eggs in this point, or embryos, without the willful, consent of the couple or the woman receiving the treatment. So our concern is the devil's always in the details. And, we don't, intentional could be you're doing a procedure, intentionally doing a procedure. You may not be using the right material, but you are intentionally putting back sperm, egg, embryo. But you don't realize, because perhaps your lab has made a mistake, there's been a mislabeling of that specimen, and you have now basically committed by in this case, either negligence or a crime. We don't want the physicians who are carrying out this work who have unintentionally made a mistake, be prosecuted for that. That's my concern, and I think the amendment does address that particular issue. And so that's all I really wanted to say. And of course, if any of you have questions about what we do, I'm here to help, because it can get confusing. I know Representative Neal has a look of, what exactly do we call this? We call it an embryo transfer usually. So.
Well, and give me 1 second, Representative Neal. I just want to clarify. So, with the amendment that's been distributed,
we're okay with it.
You're okay with it
because it specifies actual knowledge, and to me, if you actually know you're going to put a wrong sperm, wrong egg, wrong embryo into that, to that victim, that person, then it's pretty clear you've committed a crime.
Yes.
So we don't have a problem with that.
I would say that's sort of the flip side of Maisie's comment,
Right.
is if it is negligent, we're not trying to criminalize it
Right.
here, but if it's intentional,
Right.
it is.
And if it's negligence, it's going to be brought out in malpractice in some kind of lawsuit that's going to get settled a different way, which should. But if you do something intentional, and I understand that's what brought this bill on, because I was concerned when I heard about it. It was like, okay, wait a minute. There's intentional, and then there's the unintentional that could be sought or misconstrued as intentional.
Representative, I'm going to get to you in a minute. I'm just using my prerogative here. Ask a few questions up front. So, the Netflix special, which I did not have the benefit of seeing either, apparently involved use of the male
his sperm
genetic material.
Right. Correct.
But does some of your practice also involve use of eggs as well?
Correct.
Okay.
From an egg donor. Sperm embryo donation, that is where there are embryos that are created that are sometimes donated back to our embryo bank that are put into a couple knowingly. So if you use the wrong embryo, that could lead to unintentional, negligence. So those are the things that we're concerned about.
And as I read the bill, it would catch both occasions. I suppose the one that's more common is
The sperm
the
donor,
one that was
right.
depicted in the special.
Yeah. And thankfully, that a lot of the cases that were borne out were when you could still use fresh donor sperm. Because of the HIV event in the mid-'80s, almost all sperm now that is inseminated, unless it's husband sperm, is from a bank, from a sperm bank. And the bank you were talking about did not do a very good job of screening that particular sperm donor for some other mental issues, schizophrenia. But yeah, most of it, all the cases you've heard about that have been reported of late have been from before the law stated you had to have frozen sperm used because of the HIV screening process, which requires a quarantine.
That's it. Okay. All right, Representative Neal, thank you, sir.
Okay, well, you're welcome.
Yes, thank you to the chair. So I think you might have answered the question. I'm not sure. And for lack of better terms, like the chain of custody of the sperm or what have you, whether it's the lab or the bank you reference or somebody that put the wrong sticker on what have
Right.
you, you're saying that the amendment
We would
protects
cover it
all
because
those people from
because that
lawsuits or
would
what
be
have you.
not actual knowledge.
Okay.
That's correct.
Okay. I think that's all I got.
Thank you, Representative Neal. Any further questions of this witness? I don't see any, Doctor. Thank you.
Thank you for letting me speak.
Thank you for coming today. Anybody else wish to speak to this bill? All right, why don't you come up, if you will, and just introduce yourself and tell us what you're here to talk about.
Sure. I'm Lynn Goldman, and thank you to the committee for allowing me to speak. I am a reproductive technology attorney, and I'm a partner in the firm of Claiborne, Fox, Bradley, Goldman, and I've been drafting contracts for people that are using donor egg, sperm, embryos, or using a surrogate. And I just learned about this bill about an hour and a half ago, so thank you for letting me run down here and come and speak with you. And while I really think that the intent of the bill is needed and necessary, my concern is really with some of the language that's being used and the unintended consequences, that it bleeding over into things that we're not intending. And so I can kind of go through some of those in the bill, if that's okay to talk about. Yes. Okay, so, and until I got here, I have not seen the amendment, so I apologize. But for example, one clarifying piece is the term donor. So in our laws right now relating to fertility, we don't have a definition of donor. So it's great to see one. In our case law, we don't have a definition of donor. However, I'd love to see some clarification in it. I'd love to see, and I will say we have an embryo donation statute, and in that statute, we don't use the term donor. It's legal embryo custodian. So just the confusion between the terminology between the statutes is a little confusing, and if we could have some clarification, that would be great as a practitioner. But I would love to see lines 13 and 14 say that a donor means a person who donates and relinquishes future rights to human reproductive material anonymously or to a known recipient with or without compensation. Just some clarification. And I'm happy to give my thoughts in writing if that's helpful too. And then the other thing is, sure.
If that's okay.
Yeah.
So if they relinquish rights, what if it is the parent? So we're gonna go back to the example of my husband. So would he be relinquishing his rights to his genetic material?
Correct. So when I draft a sperm or an egg donation contract, my contract states that the donor, let's just go with sperm for an example, that the sperm donor is donating their genetic material, relinquishing all rights to, and relinquishing their rights to any child that results from that donation to the recipient intended parent. So the person receiving that genetic material. And if I'm doing an embryo donation agreement, I actually spell out in the contract the particular embryos, embryo number 1, 2, 3, 4. They all have identification numbers so that it's specific, so that when it gets to Dr. Toledo, for example, he knows these are the exact embryos to transfer to the intended parents.
Okay, so what about in the case of a surrogate who is carrying a child for someone else? So I'll give the example of a same-sex couple. If there is a surrogate carrying a child for two women, if they use their eggs, would they be giving up the rights to their child if the surrogate later decided that they wanted to keep the child?
So let's back up with the surrogate. So surrogates are gestational carriers.
Right.
So the child that they are having is not genetically related to the intended parents. So in the case of two women, and let's say it's one of the women, the first woman, let's say woman number one's egg, that's being used to create embryos with sperm from a sperm donor. And let's say it's a sperm from a cryobank. And so that creates an embryo, and then that embryo is transferred to a gestational carrier. So it is not the surrogate gestational carrier's genetic material.
Correct.
And the child that results is going to be the intended parent's child, so those two women.
Right.
And we actually get a court order declaring the intended parent's legal rights before birth. So it's spelled out that the surrogate has no rights and the intended parents have all the rights, because it's their genetic material and their sperm that they received from a donor.
Okay, so who takes on the rights of the genetic material? You're saying that the
The
company
recipient.
does.
No, so you have, let's say you have two women, okay, and they've received sperm from a cryobank.
Right?
There's one here in Georgia called
they use-
Zytec.
Okay.
They receive sperm from Zytec, okay, and they use their egg. They take that sperm and create embryos. Those embryos will then be transferred by Dr. Toledo, for example, to a gestational carrier to be, for lack of a better word, the oven, and carry the child for 9 months, deliver the child, and the child is the intended parent's child because it has no genetic relation to that gestational carrier. If I had a whiteboard, I'd write it all out. But there's no genetic relationship to that gestational carrier. She is only the oven, for lack of a better word.
Let me just offer one comment here. I think there are some issues we probably ought to clarify. And I think in defense of Representative Daniels, she's not had the benefit of your concerns until
No,
right
that's
now. And to be completely honest, you may have some issues here we need to address. I'm not certain that some of these issues from the context you're used to dealing with are necessarily essential for a definition of the crime. But I think they merit some further exploration.
Sure.
So rather than sort of have this discussion here in the context of the committee meeting, I'm wondering if maybe y'all we could just
absolutely.
hold this, have it just for a hearing today, and then y'all can talk about those issues. And also, we can try to work on the other three concerns that have been raised, and maybe we'll bring this back and see if we can't get it in a form that addresses the things that you believe we need to address. Because again, I'm not sure all the issues you're raising are really essential to the criminal definition here, and then
Yeah.
let's try to bring it back and see if we can't try to move it a little more efficiently.
Can I address one concern?
Sure.
Okay, when it, in regards to, in the civil section, line 43 and 44, where it talks about pending a final determination of a proceeding under the subsection, a temporary restraining order or preliminary injunction may be issued. I'm just wondering what that's envisioning, because once the gametes, the egg, sperm, embryos have been transferred, what's the restraining order? What are we restraining? That bell's already been.
I believe
rung.
what we're trying to do here is to stop the doctor from practicing if he's in the process of
Okay.
getting convicted.
So I think that's a little confusing. And then also an injunction. What would be the injunction? Again, the practicing, or is that the injunction that the recipient who's now pregnant
My
can have an
assumption, I think our
abortion? I mean, I
understanding
guess
is
there's
it would,
just
it
some
would
confusion.
enjoin that particular doctor from any further activity where he would be in a position to do this again pending revocation of a license.
Okay, so I'm just wondering if the action is again, it just seems like maybe some clarifying language might be helpful.
Right, I think it probably could be limited with some language there, and that's something I'm sure the representative will look into. If y'all want to exchange
criminal law
information, we'll
expert,
try to, I don't believe we have any other witnesses who want to be heard on this bill, so why don't y'all just work on it online and then try to get it back in front of us so we can get it out of subcommittee and get it on the committee.
Okay.
But it's clearly an issue that desperately needs to be addressed. So we appreciate you for bringing that, and I look forward to
Thank you.
getting it on the rules here at some point soon.
Thank you.
All right, thank you, Representative. All right, I'm gonna toss here to Chair Lady Silcox. I've got to leave for just a minute, and I'll be back shortly. And you want to take over here? Swap. Get rolling.
Understand Representative Barrett is here. So we will go ahead with his House Bill 1123, please. If Representative Barrett, you could come forward.
Two proposed amendments too.
What are those? Okay.
Representative Reeves.
Okay. All right. Representative, if you want to just walk us through the bill.
Yes, Madam Chairman. Thank you. Thank y'all for having me today, and I hope y'all forgive me for running in and soaking wet from the rain, running across the Education Subcommittee I was just in. So, ladies and gentlemen, I'm here to speak today about House Bill 1123, which is LC number 540338. And the history of this bill is in 2018, House Bill 635 was signed into law. It was approved in the House by a vote of 158 to 0 and approved in the Senate by a vote of 52 to 0. The legislation authorized judicial circuits in Georgia to create adult abuse multidisciplinary teams, or MDTs. The purpose of this bill, which is House Bill 1123, is to make some improvements to that legislation. How does it modify that legislation? This bill makes some changes to House Bill 635 with the goal to create a statewide adult abuse, neglect, and exploitation multidisciplinary team coordinator program. With this legislation, we're proposing the creation of a statewide MDT coordinator program within the Prosecuting Attorneys Council of Georgia, PAC. The program will establish regional coordinators to work with the MDTs around the state that are established within the different judicial circuits. In addition, it proposes the creation of an Elder Abuse Justice Coalition. My great friend Vicki Johnson, who was formerly the chairperson of the Georgia Council on Aging, work across the state for elder abuse is very fragmented. There's no statewide coalition where they're talking together. The creation of an Elder Justice Coalition would bring the disparate groups together, DBHDD, DCH, Prosecuting Attorneys Council, Georgia Council on Aging, the Alzheimer's Association, et cetera, and they'll meet at least twice a year with the creation of this council. Specifically, this legislation in Section 1, it sets an expectation that every judicial circuit in the state should have a multidisciplinary team, though it gives very broad latitude to each circuit to tailor this to their own specific needs. It goes on to say that this will not be required unless and until a multidisciplinary coordinator program, as specified in Section 2, is funded within the Prosecuting Attorneys Council of the state of Georgia to oversee and manage the teams. In Section 2, lines 32 through 45, it proposes the creation of a statewide MDT coordinator program within the Prosecuting Attorneys Council of Georgia. It will create regional level coordinators to work with the respective multidisciplinary teams in each judicial circuit to schedule, to create, schedule, coordinate, and follow up on MDT meetings within their assigned circuits, and they'll draft and submit their required annual report. Lines 47 through 110, it creates an Elder Justice Coalition, the details of which are spelled out in the bill. It specifies the makeup of the council. This bill is a legislative priority by the Georgia Council on Aging, the Coalition of Advocates for Georgia's Elderly, also known as COAGE, the Alzheimer's Association, the Georgia Gerontology Association, and the Prosecuting Attorneys Council of Georgia. Representatives from those organizations are here today, including Will Johnson from the Prosecuting Attorneys Council. And Will has been very instrumental in the crafting of this legislation. And, as a former CEO of a bank, I've seen it firsthand a lot. Elder abuse, incidents of elder abuse is just rampant, and difficult financial times, inflation being what it is, and people living much longer today. The incidence is only going to get worse, and it's just going to become a chronic and pervasive problem. If we don't address it now, it will be a problem for our state and our seniors. That being said, it's a good bill. It's a necessary bill. It's really just incremental improvement on legislation that's been there since 2018, and we've worked very closely with the Prosecuting Attorneys Council of Georgia to come up with this legislation, and we feel good about it. So I think we may have some of our friends from some of the different organizations here to speak to the bill, hopefully today, if we'll allow them, Madam Chairman.
Great. Thank you so much. You do have some questions. So I think number 8, is that Representative Kendrick or is that Representative Neal? Representative Neal.
Yes, thank you to the chairwoman. Thank you for the bill. I know we've been trying to figure out a solution to this in the law enforcement world for a while, because one of the biggest issues, and that's part of my question, but it might not be my question, because the question was around wraparound services, because what I found is even when we've been trying to figure out something, which is this is a great something, law enforcement, I think at one point was having trouble as to where to take these individuals once you establish that there's a problem, there's something wrong, where, like, what that life cycle looks like. So I don't know if this speaks to that. From what I'm reading, this is just the establishment of, and then all those other wraparound services that'll be figured out later by the council or what have you. Is that correct?
If I may, Will Johnson, the elder abuse prosecutor for PAC. That is correct. That's one of the struggles we've had is who goes where, who takes someone where, which state agency. This would allow all of them at the table, DCH HFRD, which is the regulatory division for personal care homes and other such things. They would be able to identify and say what kind of facilities are available. The adult protective services would be able to provide services when it appears that there are instances, because this would cover both criminal issues as well as self-neglect and other issues like that. So it is a very broad spectrum target of elder and disabled abuse. And I think that's what's important, is we would come to the table to be able to discuss what is best for these individuals, what services do we have available. And the circuits that have multidisciplinary teams have been very good about streamlining that process and finding that out.
Gotcha. Yeah, so as a follow-up, but yeah, I do support the bill, because we've had a problem, I think, in my county when it comes to self-neglect and what to do.
Yes.
They're like, we can't take them out of their home, even though there's a lot of other factors that make it unsafe, but they're adults, they have their rights.
Yes.
And so I understand the need. So
and this would allow us to connect them to services through the AAAs, the Area's Agency on Aging, and other social service things that might be available in that particular county or area.
okay, thank you. Thank you, Chair.
Thank you. Representative Reeves?
I do have an amendment at the appropriate time, but I would like to acknowledge Gwinnett County Solicitor's here, and she has put a lot of time in elder abuse issues and teaching, and she said I could say that as long as I excluded her from this growing list of people on this committee. She's got a lot more she does in Gwinnett County, can't serve on the committee, but she is an expert on this issue, and I appreciate you bringing the bill, Representative Barrett, and I do have an amendment at the appropriate time.
Okay, if you could hold on to that. Representative Kendrick? Okay, you wave. Okay. All right, we have 2 versions of a proposed amendment, and yours is the one with writing on it, or?
It is,
okay.
Chairwoman Silcox, AM 33-2054. AM 33-2054. The one with the handwriting on it, which adds after line 5, a subsection 17, a representative from the Community Bankers Association, and 18, a representative from the Credit Union Association. And the amendment, the underlying amendment, adds Georgia MemoryNet, Emory, and Georgia Healthcare Association. There is a different association for Georgia Bankers Association and Community Bankers Association.
Right.
Both of them are on the front lines of spotting a lot of this elder abuse. So having the community bankers in addition to the credit unions, in addition to Georgia Bankers, and the 3 healthcare organizations.
I think that's a better amendment.
Thank you.
Representative Kendrick?
I had a question on. Sorry, I'm trying to get my pieces of paper together. So. Okay, maybe I have a question about children. So who's, okay, this is your amendment, 33-2054.
Yes.
So my question was for you. So the, on line 4, a representative from Emory University Hospital Foundation.
Yes, Emory in general, but they do have elder abuse specialists there in large numbers.
Okay, so
They're
anybody-
the ones who requested that language, and if we need to make it more specific as we go along, we can take that up. But that's the current language requested.
Okay. No more questions, Representative Kendrick? No. Okay. And another question?
Just wanted
Mr.
to
Chairman?
second the motion for the amendment.
Okay. So we have the motion for AM 33-2054. Is there a second? Here's a second. And this, of course, you've got the language here, so you're okay with us not reading it out? Okay. All those in favor, say aye. Oh, yes, I'm sorry. I thought there was a motion. I'm sorry. Okay. Yes. Do we have a motion for the underlying bill? Yes. Is there a second?
Second.
Okay. So now we have the underlying bill. You're correct. Now let's take up the amendment. And we have a motion and we have a second to that. So all those in favor of the amendment with the lines, the 17 and 18 added, say aye. All those opposed? The amendment passes. Now we can take up the bill. As Representative Gullett corrected me, the underlying bill as amended. Is there a motion? Is there a second? Yes, I'm sorry.
I did receive word from Georgia Senior Living Association they wanted to be added too.
Okay. So now we'll go back.
Sorry.
So, and we're going to add a number 19. So a representative from Georgia Senior Living, correct?
Yes, I apologize on that.
That's okay. That's okay.
Correct, yes.
Georgia Senior Living Association. All right, do you have a motion on the third version of the amendment? Do you have a second? All those in favor say aye. All those opposed? All right, now we have the original bill with the third version of the amendment. Do you have a motion? Okay, okay. All those in favor say aye. All those opposed? Okay, there we go. Thank you very much for coming.
Thank you all.
We had some other people to speak, but just kind of moved on. I guess they want to move on. They didn't want to talk. All right, so now we have left, looks like House Bill 1099. Representative Huddleston, thank you.
Good afternoon, Madam
Thank
Chair.
you. Do you want to walk us through?
Yes, ma'am. Good afternoon, committee. I'm going to be speaking today on House Bill 1099. It does have a sub. It's LC 481142S.
I do not have the sub. I'm sorry.
Okay. Sure, yeah.
Okay. Do you want to go ahead and
I can.
and start on it?
Yes, ma'am.
Okay, thank you.
Basically, I'm going to be speaking upon the Georgia Code 16721, which is criminal trespass. And basically what we're looking at doing is adding language in to that existing code for signs and or of purple paint to where landowners can identify their property lines, methods of either using signs and or paint. How this generated, and I would like to read the language when he comes back with that copy. How this actually originated was some landowners basically that identifies their property, basically using of signs is very expensive. And a lot of times when say trespassers may come, they remove the signs, throw the signs away, have to replace the signs and that type of thing. Other states basically within their language also uses purple paint markings to identify the property lines just like you're using a sign. So that way it gives the landowner options of either using the sign, purple paint, and or nothing at all of their choosing. So a conversation I had with a Department of Natural Resource law enforcement officer had made mention of using signage, or I'd mentioned the signs, and he said a lot of times they would basically just have to give a warning if they've come out and somebody was trespassing. So basically within that, we looked at and they said if the language was within that code section, then it gives them a little more something to stand upon if they do get called out on a trespassing citation. So basically, a lot of times we look at other states that has the ability of using methods of use, or they look at state of Georgia of how we. Basically, there's I think 15 other states that's actually using purple paint markings along with signs, and then there's about 7 other states with markings of other color. So basically, every southeastern state, Alabama, Tennessee, North Carolina, South Carolina, and Florida, has this language within their code section of using purple paint, and other than Georgia. So this would make it consistent within the state. So if you'd allow me to read, I'd love to read the language that we're looking at adding into this code section. It's basically lines 28 through 38. It says, enters upon the land or premises of another person that has been marked by the placement of sign or signs posted on the property or identifying purple paint marks on trees, posts, or property, provided that such marks are vertical lines of not less than 8 inches in length and not less than 1 inch in width, placed so that the bottom of the mark is not less than 3 feet from the ground or more than 5 feet from the ground, and in the areas of a known flood zone placed above the known flood depth. Placed at locations that are readily and clearly visible to any person approaching the property and no more than 500 feet apart from forested land and 1,000 feet on land that is not forested. Basically, I've actually spoke with a number of the, agencies that possibly may be involved, and that's the Department of Natural Resources, the Cattlemen's Association, Forestry Association, Farm Bureau, Realtors Group, and I have pretty much all support because they have helped generate, say, I'm good with the language there. Basically, on line 37, it says property no more than 500 feet apart on forested land. Basically, when I met with the Forestry Association, the original footage there was 100 feet apart from forested land, but they wanted to kind of increase it to where it would give a little more opportunity within those markings of distance. So with that, I'd answer any questions that y'all may have.
Representative Reeves?
Thanks for bringing this bill. You and I heard from somebody in North Georgia who had a similar idea before they knew about this bill, so it sounds like you're given a big need. The Army Corps, I think, uses similar method but with red paint, so they have a lot of land around Georgia, and that seems to work pretty well. In addition to their markings or their survey pins, they mark trees with red, so good idea on this.
Yeah, thank you very much. And basically that's, like I said, adding in that language of signs and or purple paint. Like I said, it just gives that opportunity for that landowner to identify those property lines for trespass. Thank you.
Representative Neal?
Thank you to the chair. I think my question might be answered because the question I had was how, if a person doesn't know what purple paint means, but if the signage is still required, then
Well, it's not required. No, ma'am. Basically, you can use signs and or purple paint of choosing or choose of nothing. Basically, being that state of Georgia, let's say this does get passed into law, basically you would, common sense, that would be a transition period of education of the public, like in rules and regs, hunting regulations, articles, just like say the cattlemen's group, I imagine would identify that with a cattleman. The forester would probably somehow have an article. So basically it would take, we would just have to identify within a transition period of education.
Gotcha. Because even when I was in my crazy days of doing marathons, when you do distance marathons through the woods, they will mark trees of various colors.
Yeah, this just gives an opportunity, like I said, pretty much for an economical cost of not having to purchase signs that get stolen, damaged, whatever. They say that actually, and you could choose any color, but the consistency within the southeastern states is purple paint that identifies as trespassing. They say that actually the purple paint is more visible from a distance than it is as the signs. So,
okay,
thank you.
Is that Representative McCullough?
So I get what you're trying to do, and I get the purple paint. Are you? I don't know the rules of trespassing, but if it's not labeled private property, no trespassing, you're saying they're not able to prosecute people for trespassing?
I talked to a law enforcement DNR officer, game warden, and he had made the statement. He said basically, if you called on someone coming out and they were saying, and this is not damages, I would assume just trespassing. He said basically they would just have to give them a warning on the first go around. And so I asked why, and he said basically because it's not within the language of the code. Now, so basically, he said that, I said, why is not the sign the first point of warning? And it wasn't because it's not listed in this code section. So that's where we kind of got to looking into it. If it's within the language here, I'm assuming, and I'm not, an attorney, but basically by being in here, the law is on the books, so then basically the warning is there. So if they come out, that gives them an opportunity that they can go ahead and cite them at that time. And then basically if there's damages, within reading of this, if there's damages of $500 or less, then it becomes a misdemeanor.
Okay, I just want to make sure that, again, I would imagine that Chairman Smith probably knows more and Reeves over there, but if they're, I just want to make sure this is going to solve the problem that we're trying to get, not just, I think that's called Blaze Marathon. That's what I think of. Purple Blaze means don't trespass. I don't know who knows that. Maybe hundreds, I don't know, maybe people.
Well, no, and that's why I said that would be a transition of education, because the surrounding southeastern states already has it within their language. So I imagine a lot of the folks, that let's say are the hunters, that's multi-state, they're probably aware of it, but it would take a point of transition of education and just, knowledge.
But if the goal is for them to be able to, arrest someone for trespassing, and they feel that they can't, that this makes them feel like they actually will now. It's kind of, I guess, what I'm trying to make, by us doing this, that they will do it versus they feel like they can't.
The word that got back to me, the word from the DNR basically said that they like the language within this code section because it does give them a foot to stand on to be able to make that arrest or citation as they go out.
Okay.
But being that it's on the books.
Okay, thanks.
Mr. Chairman.
I need to phone a friend, and they probably already know who it is, with PAC. There's an operative word here at line 27 that says or. And so I guess the question is, are you still guilty of trespass if there's not purple paint? Is that what I'm hearing? Yeah.
That's what I was saying on the other side. Purple paint exists as a sign that does not exist.
I would say this committee deals with clarifying statutory interpretation all the time, but it would seem as if they are still guilty of trespass, whether or not you have the purple paint marking on this property. But I want to hear from my friends at PAC.
Hi,
Yes.
Robert Smith, Prosecuting Attorney's Counsel. The chairman's right, because of the way where this has been placed. It's subparagraph 4 of Part B. So to commit the offense of criminal trespass, you must knowingly and without authority. So you still have to prove the without authority part to even with the purple paint, even with the existence of the purple paint. So the argument would be that, well, you saw purple paint, therefore you knew you didn't have authority. That would be how we would have to prove this. I think that's the answer to your question you're asking.
Yes, sir. And I mean, even if they didn't say purple paint, I mean, still the offense of trespass is going onto that property without the lawful authority to do it. So, okay.
And that's when I
thought that was right.
And this is similar to a bill that I think this, if not this committee, I know the broader committee has heard this session about reducing the notice requirement for criminal trespass. That basically somebody's somewhere they shouldn't be. They're rather than arresting them for loitering. The intent of that bill was to have them arrested and prosecuted for criminal trespass.
So maybe somebody needs to tell DNR they could already arrest somebody for trespass.
Or maybe not trespass, loitering. I mean, but once again, it gets into to say that you're somewhere you're not supposed to be. I mean, we are requiring, the law currently requires some sort of notice to leave. That's the key here, and I think that's what the intent is to, hey, you walked past a tree with purple paint on it, therefore you knew you weren't supposed to be here. I will point out that purple paint laws do vary from state to state. In North Carolina, it simply means you can't go on the land and be able to hunt and fish. And you also have to put it certain places, certain distances from the streams and creeks.
Robert, are you referring to the squatters bill, or?
I'm referring to the bill that y'all heard earlier this year about, and I think it was the hypothetical that kept coming up was somebody getting in somebody's car and wanting to have them arrested without having to say, "Hey, get out of my car."
Okay. Yeah.
Yes.
Okay. Thank you, Robert.
Okay. Representative Neal.
Yes, and I think my question is to the chair and the author. So, are you feeling like the purple paint is reducing notice?
I think it's supposed to serve as notice. Sorry.
Yeah, it would be an increase of the notice, basically. So, you know how, if you look at our laws in the state of Georgia, especially concerning pedestrians crossing, rule of thumb is pedestrians always have the right of way, but within the proper area in which to walk.
Right.
This is providing more notices like, look, they should already know they shouldn't be here, but here's a little extra of incentive so you don't break the law by committing trespass. So this would provide more notice.
More notice. Thank you.
Is there any more discussion or questions? Do we have a motion? All right. All those in favor say aye. All those opposed? All right. The bill passes.
Hey, thank you so much.
Thank you. Let's see, and I guess we're just on endorsement. Representative Kendrick?
Yes.
11:37. Absolutely. You did great. You did great, David. All right.
Is this one on? Okay. Thank you, Madam Chairwoman and members of the committee. I can say with confidence that I am an attorney, but I don't practice this type of law, so I have my good friends at PAC as well that have been helping me through this process. So I have House Bill 1137, LC 481151, and the crux of this bill is to allow prosecutors to hide grand juror names. We have seen an increase, as we heard from the state of the judiciary. There's just been an increase in violence against elected officials, against jurors, against people that are responsible for securing our democracy and making sure that our judicial system works. And so this bill is drafted to allow for our prosecutors to hide those grand juror names. You will see, well, you won't see, but I will tell you, thank you to the good work that our research analyst and my office mate Brian did on this. 28 states require the foreperson to sign on behalf of the other jurors. And so I can get you some additional information just comparatively about what other states do. But that is the bill in a nutshell, and I'll see if there are any questions.
So I guess what is being changed?
So right now, there is no ability for prosecutors to hide grand juror names. So you'll look at particularly line 10. The words may easily be understood. So right now, there's a certain form in which the indictment has to be formatted, and it has to list the names, and there's no discretion in the code for prosecutors to hide it because it has to be in a certain form. So by changing and adding those words, if a prosecutor does put an indictment that does not have the grand juror names, it will be sufficiently technical and correct as a correct indictment. Did I explain that correctly?
So there would be no names at all?
Yes, if in the prosecutor's discretion. So it wouldn't automatically say that there would be any names, but in a high-profile case or there's high tensions, then the prosecutor can say, hey, this might be a good idea to just hide the grand juror names.
Which I understand in theory, but I guess in practice, if you could hide these names later, would that be something that, would be a negative in terms of the final record of the disposition of the case? I mean, I would think that we would want a permanent record of who convicted someone or who.
Now, it's my understanding, and tell me if I'm wrong. So make sure I'm not saying anything wrong. It's my understanding that there still would be a record, so it's not like you go to the courthouse and request it and it'll be like a blank sheet of paper. So the purpose would be, when the prosecutor has an indictment, to make sure that when they're sending out these press releases or, it's in the public sphere, that you're not having those names sort of put out there and easily available, but they still are available. You just have to go through a different loop in order to get them.
There's no federal law or federal right to the names of the grand jury.
Okay.
Basically, they're all. What you do have a right to is a fair cross section of the community. So the names would still be available, and if a defendant felt like within the amount of time that they're given to be able to challenge the grand jury array, they'd still have the opportunity to go down to the clerk's office, get the names, or get the biographical information that they need to race, sex, to be able to say that this is not a fair cross section of the community. So that information will still be there. The idea is that in Fulton County, every 2 months, there's a brand new grand jury.
Mm-hmm.
But even here, we've had grand jurors be threatened.
Right.
Their names have been put out there for various cases. But what about a case in a jurisdiction where the grand jury only switches every 6 months? So those are the same people who hear the cases week after week. So the idea is that I'm going to go, somebody who's nefarious realizes they're going to get indicted, or they could get indicted in a few months. They go and see what the grand jury, who was on the grand jury earlier in the term, gets those names, and then they can approach those grand jurors. They can threaten them. They can put their information out there. We have a problem right now with that information getting out there and how it's being misused. It's threats to judges, threats to law enforcement officers.
So as long as it would be preserved for an appeal, that would be fine. That was my question.
Sorry.
Okay, Representative Neal.
Yes, thank you to the chair. Thank you for the bill. I do trust the wisdom of PAC. They're great partners of this chamber, and I'm very familiar with this initiative. So at the appropriate time, I move to pass.
Okay, we got one more question, Representative Gullo.
Yep, thank you for the bill too. So I understand what you're trying to do. I'm trying to get to if I agree with it or not. I served on a grand jury. I've served on a regular jury. Grand jury is one of the was an awesome experience for me. It was in Gwinnett County. I think it was a 6-month grand jury, met every 2 weeks. But at some point, I think when you're accused, you should have the right to know the accuser. You should know the people that are indicting you. You should know the jury that's putting you away. You should have that information. So I'm trying to get my brain around if I go to the clerk's office and I get that information because it's available to you, right?
Mm-hmm.
But not publishing it in a press. Like, does it really do what you're trying to do? Is it really protecting a jury? If someone can go to the clerk's office and get that information, or, who's threatening the people? Is it people on behalf of people? Like I'm part of this movement and I'm upset that you've arrested these people, or is it the people that have been indicted who are furious at being indicted, or who's doing the threatening? I guess that we're trying to solve for.
Well, I can tell you in the article that I read, it is sort of online groups and communities. So the reason, this bill is obviously not going to solve the issue of people not getting, grand jurors not getting harassed. The point is to make it harder to do. And so the reason that those online communities, it was really easy for them to take the jurors' information and sort of harass them is because it was public, right? They didn't have to go down to the clerk's office. And my theory is if they had to go down to the clerk's office, not only would we know, be able to catch them faster, but also it would I don't necessarily think they would have taken the trouble to do that because, with the internet, you can just play a bandit anywhere and post anything anywhere and not have to go through that extra step. So it's not going to 100% solve the issue, which that was never the intention. The intention was just to make it a little harder to threaten grand jurors.
And you believe in PAC's world that this will make it harder, that this will do what the goal is?
Yeah.
Outside of whether you support it, I'm asking
Yes,
Robert. Sorry.
this will make it more difficult. And like at the federal level, you don't have a right to this information. The only reason why the defendant has this right to this information right now is because it's the way the statute's worded. There's multiple states, and that's some of the research that's been done. Multiple states, just a grand juror, 4 persons enough, their signature. So Georgia is an outlier in how our grand juries operate, and the requirement that all the names be published on every bill of indictment makes us different than most states. And I submit that it makes us different to the detriment of the safety and well-being of those grand jurors.
But for the transparency, but for the good of the transparency of the process.
You don't have a right when you get indicted to
Yeah.
have those grand jurors come back and testify. What you have a right to do is make sure that those grand jurors are not felons, that they don't have an impermissible relationship to the accused or the witness who testified, the prosecuting witness who testified, and they were residents at the time of their vote, and they were a cross section of the community. You don't have the ability to haul them into court and say, well, tell us about the information you heard today, and did you really think there's probable cause or not? You can't do that. So really, all you're kind of doing is making sure that you've got, these people were randomly selected by the list that was prepared by the AOC kind of thing.
Okay, thanks.
Mr. Chairman?
Thank you, Madam Chair. To the bill author, do you know when the last time it was that the legislature took up this statute and did anything with it as far as changes or amendments to it?
I've been elected for serving 14 years, so at least not in the last 14 years.
Okay, so we don't know the last time it was messed with. I guess the next question is more of a policy question for the bill author again. Why does the public not need to any longer have the right to know who was on a grand jury?
Well, it's not that they don't have the right to know, because again, they can still go and get the information. It's just we're not making it easy for them to get it by publishing it in every bill of an indictment. So they still have access to the same information. All we're doing is putting an extra layer, and we're really trying to catch not the public. We're trying to catch the people who are doing the threats that are trying to block and intimidate grand jurors. So I believe in transparency as much as the next person, but sometimes in our efforts to be transparent, people get harmed, and so I'm trying to put an extra layer of protection without, violating anyone's rights or anybody's ability to get the information, just giving one more step to get the information.
But under your scenario, they could still, and even with this bill, they could still get that list of grand jurors and still harass them. And, even though it's just one more hurdle, they could still achieve the objective of trying to harass these grand jurors. Wouldn't you agree?
No, I agree. But again, it was never the objective of the bill to prevent that, because I think then we get into constitutional issues if we try to prevent it outright. All I'm trying to do is make it a little harder.
Okay. And so what you're saying is that under this bill, they could, a member of the public could still file an open records request and get this information?
Correct.
Okay. I'm just thinking, I think it's a noble effort, obviously, but I'm sitting here thinking I would prefer some clarifying language to that effect, as to, this does not impede a public records request, or, obviously the defendant's going to be, entitled to a list of this, but even still, I would be interested in some limiting language there as to, how far this obstacle would go, just to make sure that we don't sit here and, July 30th or July 1st or July 31st, we can't access any of this information, and we've effectively limited the public's right to know who sat on a grand jury. Just a policy consideration that I would submit that we think about.
And so just to clarify, so you would like specific information, even though we don't touch the Freedom of Information Act, but a clause in here to say that it will not have any bearing on the act.
I think with a matter of this, and this is just policy consideration that we can think about as we go forward too, that we would, as we do in a lot of code sections, we change something in one code section, it's going to affect the other one. But at the end of the day, even with all of our best intentions, we've got somebody up on the bench that's going to interpret these statutes and what our intent was. So just to make sure, I think that some clarification and guardrails, so to speak, might be in order. I mean, sitting on the bench right now, let's just say, sitting as a judge, would interpret this statute as not impeding that right to this information of who sat on this grand jury through an open records request. That would be, I think, prudent in the environment that we find ourselves in. But just reasoning together here today, just thinking through that. I know that's not your intent, but just to make sure that we clarify for those that make these decisions.
Yeah. Did you have a suggestion?
The clerk of court is not subject to the open records law. So what you'd have to do is, the intent is, if you want this information, you just go down to the clerk's office, and the same way you request any other court filing or something like that, you could get it that way. I mean, unless your intent is to bring the clerks underneath the Open Records Law Act.
I don't think you want to do that, Mr. Chairman.
And okay.
It wouldn't, but as far as the public's access to this information, that's really what I'm getting at, because I think that's a step, even though admirable for your reason for bringing the bill, is still, I think the public's right to know, and us impeding that right with just another obstacle. It's not a total deprivation of the right, but just it's another obstacle for them being able to access this information that concerns me.
In this day and age, when we're talking about doxing, we're talking about protecting people, and one of the things to consider and remember is that and this is back when the discussions that the court had with the COVID, when someone is sent a juror summons, they're being compelled to come into court. They're being brought in without, they don't have a choice in the matter. So this is one of the ways to kind of safeguard that information. I also, one final point on this, there is a school of thought that providing these names to the grand jurors is prejudicial to the defense. So this is one of those weird instances where, prosecutors kind of like, basically what we're seeing is, hey, we want to protect our grand jurors, and there are segments of the defense bar that have been saying for years, stop putting the names on the grand juror, stop putting the names of the grand jurors out there. So it's a weird intersection now where both sides are kind of saying the same thing.
Representative Neal?
Yes, thank you to the chair. So I guess my first question would be, is it not true that this would be considered more or less a deterrent? So to Robert's point, if you do want to harass anyone, you have to take the extra step of going to the courthouse, passing through the sheriff's deputies, and taking that path to do so. And you can still access this information, like you mentioned, without having a formal open records request. So with that being said, I guess on behalf of of Chairman Smith, I wanted to make a motion to do pass, but if you had an amendment you wanted to consider before doing that, are we open to all of that?
Thank you. Thank you.
Okay.
Thank you.
And I have the language.
You have an amendment to offer?
Yeah.
Oh, I'm sorry. I guess why don't you come on up, Maisie? Yeah. Yeah. Maisie Lynn.
Thank you. I appreciate that. And so do my grandmothers. God rest their souls. So I have spoken with Representative Kendrick about this, and I realize it is not her intention to set up barriers to work that the defense bar needs to do. I do not come in agreement with PAC, as Mr. Smith has just stated. That's simply not true. We have concerns about this legislation. There may be individual actors within the defense bar who agree with it. As an organization, we don't, in part because it's more than just the matters that Mr. Smith mentioned that are important in knowing who the actors are on a grand jury. For instance, no elected person, none of you can sit on a grand jury at this time. Obviously, it was before you were elected, right? Right. No one who sat on the grand jury can then sit on the petite jury, who actually tries the case. There are some other individual requirements in Title 15 and Chapter 12, and we are the guardians of those rules. And mistakes have been made, and I don't suspect they've been maliciously made by our friends across the aisle of the courtroom, but they've been made. And it is important that there is a check, and we can't check it if we don't know who the people are. I also don't, when I was in practice, I didn't enjoy what Mr. Smith described, the ability to walk up to the clerk and get anything I want. We are treated as the public in that space as defense lawyers, and it's true that there is not subjectivity to the Open Records Act in the clerk's offices. So for us to be able to, my concern is less about the public nature, which I think is a policy matter for you all to address, the public nature of this information. But in order to do our jobs as defense lawyers, we need these names. And so if there is some other mechanism by which you would like to protect the disclosure to the public, great. There are ways you could do that, for instance, by redacting anything that's provided to the public. But as defense lawyers, we still need to get this information. And right now, we get it through discovery because it's included on the indictment. That is the mechanism right now of how we get this information that we need in order to do our jobs. And we don't love the idea of having to come down to the courthouse in a separate visit to get information that ought to be provided to us as part of the discovery process like it is today.
Thank you, Mr. Chairman.
Thank you, Madam Chair. So, just trying to make sure again, unintended consequences. Our discovery statute, this very well could be interpreted by a DA that they don't have to disclose the names of the grand jurors to the defense unless the defense makes a specific motion requesting the name of those grand jurors. And then you could even see that there may need to be good cause shown for that. And so that could very well be an unintended consequence of what the letter of the law here would purport to accomplish.
And possibly, I mean, and I appreciate too the idea that that this kind of discretion could in theory be narrowly tailored to only happening during high profile or high tension cases, but without that kind of, there's nothing in the bill that would limit the prosecutors, the district attorneys from picking and choosing which cases they apply this to. So my request is that if these names are going to be protected from public disclosure, that consideration be made of how the actors within the system who have work to do there can most effectively and efficiently still do that work that we're charged with doing under the law and the Constitution.
Chairman Leverett.
Thank you, Madam Chair. So there's nothing more annoying than the guy who walks in late and starts asking a bunch of questions. But let me just walk in late and ask a few questions. So as I read the bill, although the title says prohibit disclosure of grand jury names, nothing in the substance of the bill itself necessarily does that, does it? It just says you don't have to list them on the form of the indictment.
Right. So as of for today, for your indictment, for a prosecutor's indictment to be sufficient, to be a sufficient legal vehicle for prosecuting someone, it has to list the grand juror names. If this bill were to pass, it would allow for that document to be sufficient without those names.
Right, and I understand that's your concern, but it's not prohibiting the dissemination of those names otherwise, I don't think.
No, it's not. It's just, it's to the sponsor's point, making it more difficult to find those names for everyone,
Including defense
the
counsel.
bar.
Yeah. So would that, and again, forgive me because I don't know a lot of defense work, but would, as I understand, there is a criminal discovery statute. And does it mandate any particular disclosures, or is it only in response to a specific request from defense counsel?
There are mandated disclosures.
Okay. And I'm assuming the identity of the grand jurors is not one of those disclosures currently.
I would be happy to defer, but I don't believe that's there's not a requirement specifically listing the disclosure of grand juror names in the discovery statute.
It's on the right now. It's on the statute.
It's on the indictment.
And if you don't have the names on the grand jury bill of indictment, the indictment is defective, and it can't be used as a charging instrument. And
that's how we get it.
And the Supreme Court opined back many years ago, that but for that statute, you don't have to have them on there.
So I understand the issue is currently it would be a defective indictment if it did not list the names because of the statutory requirement that you identify those names. If we remove the requirement here, we're not necessarily prohibiting any other public disclosure of it. I don't see any express public disclosure. I guess the question I'm just posing is, would that arguably be included in the mandatory disclosures, or can we, that's presumably something we could change, perhaps as part of a comprehensive revision of the way those names would be treated?
I think your point is that if there's another mechanism by which they are already required to be provided, but I don't believe there is.
Well, that was the point, or should there be? I mean, I think you're raising a valid point. You've summarized it. Is there a way you would already get it anyway without having to go to great effort, or is there a way we could make that the case as part of this bill?
I mean, right now we get it because they're on the indictment. I mean, that's just the reality. That's how we get them. So
and that is nice and easy, but presumably you could still get them because we're not prohibiting the clerk from releasing that information.
Right.
But your concern is that's another step you got to go through, which is, I mean, I understand.
And more work for the clerks, quite frankly.
Yeah.
But I'll let Mr. Hallman handle that issue.
I was just going to refer or kind of converse real quick with my chairman. that is the concern. Like, there's some open ends here that we don't want to get to July the 1st, and, you know, then how do we get this information? Are we allowed to? And just, in a perfect world, yes, defense can still get this information. Just making sure, and I think there's a transparency concern too here altogether. So that just to kind of bring you up to speed.
And I would just add, since I've pulled the code section up now and looked more closely, this particular code section has not been touched since 1933.
1933?
The Code of 33.
Wow. Okay.
33, the Code of 33.
Older than Leverett.
Wow. And I'm. And I feel like I want to be fair. I'm just quickly looking through Discovery Code. I don't quickly see indictment grand juror names separately listed. So I'm not confident that there's another mechanism in place now.
I would imagine you would express that.
Yeah.
Mr. Chairman.
Well, since this was last updated in 1933, I think Franklin Roosevelt had just been sworn in. And I can't remember who would have been governor then. It might have been E.D. Rivers. Or actually, I think it was Richard B. Russell, Jr. Madam Chair, I'd like to consult that old legal authority that we brought on the book with us by the name of Sir William Blackstone to see if there's some insight as to whether we need to keep this the way it is, or as the true noble intent of my learned profession colleague, that we can do this. So at this time, I'm going to move to table this bill just to get some more assurance that we can,
There's a second.
you know, be comfortable with this going forward.
All right, there's a motion and a second to table. All those in favor? Aye. All those opposed? No. Okay. The ayes have it. Thank you. We are adjourned.